Okay, I think we will begin. Thank you. So, tēnā koutou, tēnā koutou, tēnā koutou katoa. I'm Lee Godden. I'm the Dean of the Faculty of Law here at Te Herenga Waka, Victoria University of Wellington. And it's my great pleasure to welcome you tonight, all our distinguished guests, and to welcome you indeed to the inaugural 2023 Ivor Richardson lecture. And my duties tonight are quite brief. I have to inform you of some health and safety information and then some information about refreshments afterwards. Then I'll move to just say a few words about the Ivor Richardson lecture before handing over to Justice Mark Cooper, President of the Court of Appeal. We will have our distinguished speaker speak to us for around 40 minutes, and then we will have a vote of thanks by Professor Graham Richardson. And following, within that process, there'll also be an opportunity for questions. So that's the order of proceedings for tonight. So that health and safety information. For those of you not familiar with this facility, many of you will be. You've probably sat in these seats before. We have the bathrooms around the corner on the left of the foyer. And in the unlikely case of an emergency, could I just remind you, particularly if it's an earthquake, which as a person not from Wellington, this is always quite a thing for me to say, that we should exercise that emergency procedure of drop, cover and hold that I'm sure Wellingtonians and indeed other people from New Zealand are much more familiar with than I. Now, should we need to evacuate, could we please use the main exits and make our way outside the perimeter fence across into the street area. The refreshments will be held up on the mezzanine level, and we have our wonderful engagement and communications staff just outside the door who've welcomed you this evening, and they'll show the way upstairs. Now I'd like to say a few words about the Ivor Richardson lecture. And for many of you, you'll be much more familiar with this than I. So I think it's just a great honour that I've been asked to provide those few words, and I'm sure many people in the room have a much greater depth of knowledge than I. So the lecture has been established in honour of Sir Ivor Richardson and his extraordinary contributions to New Zealand jurisprudence and the teaching of law. Sir Ivor Richardson was a professor of law at the university from 1967 to 1973, and he served as Dean of the Faculty of Law from 1968 to 1971, and from that position went on to be the Chancellor of the University from 1984 to 1986. So his contribution to legal education and university education, I think, is recorded in those dates. Sir Ivor was then appointed a judge of the High Court in 1977, and a few months later elevated to the Court of Appeal, where he sat until his retirement in 2002. Could I also record that this lecture was created in partnership between the Michael and Suzanne Boren Foundation, the judges of the Court of Appeal, and the Faculty of Law at Te Herenga Waka, Victoria University of Wellington. And that is a relationship that is a wonderful one to celebrate and acknowledge and to strengthen as we move forward. It's also an opportunity to record that this is an annual lecture with a focus on private law in action, and that our chosen speaker is one of New Zealand's leading lawyers and legal scholars in this area. I'm now have the honour to introduce our speaker tonight, Justice Mark Cooper, President of the Court of Appeal. Justice Cooper graduated LLB Honours, Master of Jurisprudence Distinguished from the University of Auckland in 1979, and joined Butler, White and Hannah which later merged into Simpson Grierson. He commenced practice as a barrister sole in 1977 and was appointed Queen's Counsel in 2000. He was appointed a High Court judge in 2004 and a Court of Appeal judge in 2014. Justice Cooper is of Ngāti Mahanga descent and iwi of Waikato Taunui. Please all welcome Justice Mark Cooper.
Yes, thank you. Tēnei te mihi, ki te whare e tūnei, ki na mate o te wā, ki na hangaora e hui hui, mai nei raro e te korowai i te Ngāti Awa. Ki te rangatira tā Ivor Richardson, koutou ko tōna whānau. Tēnā koutou, heina koutou, tēnā toutou katoa. And as I say, when I speak in Te Reo, I should translate for the benefit of others who speak Te Reo and English people alike. I've greeted the House. I've referred to the recently departed, to the living gathered here under the cloak of Te Awa, and to the esteemed person in whom these lectures are honoured, for whom these lectures are devised, Sir Ivor Richardson and his family. Greetings to you all. Can I add my thanks to the Boren Foundation for their support of this event, and also give the apologies of Professor Megan Richardson, Sir Ivor's daughter, who's at the University of Melbourne Law School and cannot be with us today. I too had planned to say a few words about Sir Ivor, and will do so, hoping not to cover too much ground already covered. The theme of these lectures, Private Law in Action, would be an unduly narrow one were it aimed at capturing Sir Ivor's many and varied contributions to New Zealand society and good government. Certainly his career was distinguished for the action it involved. Starting his professional career in litigation and beginning in private practice in Invercargill, working for the Crown Solicitor, Sir Ivor moved to Wellington to become Crown Counsel as part of a shake-up of the Crown Law Office. And I've heard it said that it was prompted by the thought that Sir Richard Wilde had that we need somebody here who knows something about tax. His next move to Victoria University is, of course, particularly noteworthy. He became a professor with a particular focus on taxation law, and then the dean of the law faculty. His tax seminars are remembered for the way he brought the subject alive, both because of his own keen interest in the principles and policies underlying tax law and his involvement in contemporary litigation. As well as serving as the dean, Sir Ivor went on, when he was a judge, to serve as Chancellor of Victoria University, and he's remembered for his collegial style and manner, which is said to have refashioned that role. Following his time at Victoria, Sir Ivor made a brief but action-packed return to private practice. The late Sir John McGrath, in a tribute to Sir Ivor, perhaps summed up the essence of private law in action when he recounted one particular anecdote from this period of Sir Ivor's career. Apparently, one Sunday morning, Sir Ivor returned to New Zealand, having just appeared before the Privy Council in London, and he learned that he was required to travel immediately to Dunedin, where a major investment company was in financial trouble. By the next morning, the government had accepted his recommendations on the matter. New management was put in place and legislation was passed based on Sir Ivor's proposals that would protect investors from a rush on funds. That, Sir John explained, was the origin of statutory management in New Zealand. Sir Ivor had a remarkably brief stint, just 6 months in the High Court, before he was appointed to the Court of Appeal. I will not attempt to do justice to his judicial career this evening. Suffice it to say, Sir Ivor's work as an appellate judge for nearly 3 decades touched on all areas of the law. It coincided with a period of change in law and society, when, in the former Chief Justice's words, a series of cases in which Sir Ivor presided blew away the cobwebs of formalism. Interpreting legislation and developing the common law with a close eye to economic and social context. During his tenure as a judge, Sir Ivor continued to serve government in various capacities, most notably as chairperson of the Royal Commission on Social Policy and the organisational review of the Inland Revenue Department. It is perhaps in part due to this role and the later role that a former Secretary of New Zealand Treasury remembered Sir Ivor for his massive contribution to taxation policy and administration. At a memorial sitting for Sir Ivor on Friday, the 1st of May 2015, Chief Justice Elias said that in the many messages that arrived after news of Ivor's sudden death was one from the Chief Justice of Hong Kong, expressing sadness and the gratitude of the people of Hong Kong for Sir Ivor's service as a member of the Hong Kong Court of Final Appeal between 2003 and 2009. It concluded by saying of Ivor that he was a true giant in the common law world and will be recognised in legal history in that way. So, having delivered that necessarily incomplete and limited snapshot about Sir Ivor, it's now my pleasure to introduce Ms. Sarah Grimmer. Sarah, like Sir Ivor, has led an impressively varied career, though with a particular focus in international arbitration. Sarah is a graduate of this law school and is fondly remembered by faculty and fellow students as being an outstanding pupil. She also obtained an LLM from Cambridge University. Sarah began her career in private practice in Auckland, but quickly moved on and fled to greener pastures in Paris, working first for the International Arbitration Group of Shearman and Sterling, before joining the ICC International Court of Arbitration as assistant counsel. Sarah then spent a decade at the Permanent Court of Arbitration in The Hague, where she administered complex interstate, investor-state, and contractual disputes. Prior to her current role as a full-time arbitrator at 20 Essex, Sarah worked as Secretary General of the Hong Kong International Arbitration Centre. There, she contributed significantly to the centre's reputation as at the forefront of innovative arbitration practice, including by overseeing the launch of a database of the centre's procedural decisions and an online case management system. Sarah is therefore well placed to speak on the theme of private law in action, which I'm told she will do by reference to the role of domestic courts in international arbitrations. Please join me in welcoming Sarah to speak with us.
Good evening, distinguished guests, ladies and gentlemen, students and friends. It's my great pleasure and privilege to be here this evening under the name of such an influential, well-respected judge. And I'm very grateful to all of you for taking the time out of your busy schedules to be here with me tonight. I will be speaking about the role of the national courts in international arbitration. While I was working at the Permanent Court of Arbitration in The Hague in 2013, I was the tribunal secretary to an arbitral tribunal in a very interesting case. It involved a claimant, Sanem Investments Limited, which was incorporated in Macau, which, as you know, is one of the two special administrative regions of the People's Republic of China, along with Hong Kong. Macau was returned to China by Portugal in 1999, just as Hong Kong was returned to the People's Republic of China by Britain in 1997. So in this case, Sanam had invested in casinos and hotels in the Southeast Asian state of Laos. And it alleged that the Laotian government had deprived it of the benefits of its investment through discriminatory taxes. It commenced an international arbitration in 2012 against the government under a bilateral investment treaty concluded between the People's Republic of China and Laos. That treaty provided that disputes involving the amount of compensation for expropriation could be settled by international arbitration. Laos raised two jurisdictional objections to the tribunal. First, that the Chinese-Laos Treaty did not apply to Macau, and it did not protect Macanese investors like Sanam. And second, that the claim was not arbitrable because it was not a dispute involving compensation for expropriation. Rather, it was a dispute over whether an expropriation had occurred at all. The tribunal deciding the matter was composed of three highly experienced international arbitrators and international law experts. They had to decide whether the China-Laos Treaty extended to Macau, and under the customary international law rule of moving treaty frontiers, which says that when a state acquires new territory, its treaty regime automatically applies to that territory. That would be the default position unless a different intention appears from the treaty or it is otherwise established. One of the members of the tribunal was an internationally recognized authority on the law on state succession. The case involved complex issues of international law, and the tribunal reached its decision after much briefing, hearing, and deliberation. It determined that it had jurisdiction, finding that according to the default customary rule of international law and the facts, the Chinese-Laos Treaty did extend to Macau, and that the claims of expropriation of the investor Sanam were covered by the treaty under a proper interpretation of the treaty. Shortly after the tribunal issued its award, Laos applied to the courts at the seat of arbitration to have it set aside. Those courts were the Singaporean courts. Under the Singapore International Arbitration Act, if a tribunal rules in a preliminary finding that it has jurisdiction, any party can apply to the High Court of Singapore to decide the matter. Accordingly, a judge of the Singaporean High Court, sitting alone, decided the matter after much briefing, hearing, and deliberation. The judge found that on the basis of the facts that were before the tribunal, the Chinese-Laos Treaty did not apply to Macau. In light of this finding, he acknowledged that it was not necessary for him to determine the second jurisdictional issue, but he set out his brief views on it nonetheless. And he concluded that the text of the treaty should be given a restrictive meaning and that the tribunal had no jurisdiction over Sanam's expropriation claims. Just between us, when the Singaporean High Court judgment was rendered on the 20th of January 2015, I almost fell off my chair. Had I been in New Zealand and had I received the health and safety warnings, I would have known to duck, cover, and hold. How could this national court judge set aside the jurisdictional findings of an international arbitral tribunal composed of international law experts who had carefully determined complex issues of pure international law? Should not the court have shown deference? This case raised questions in my mind about the role of national courts in the international arbitration process, particularly in reviewing arbitral tribunals' jurisdictional decisions, and particularly in the international investment arbitration context, hence the topic of tonight's discussion. The judgment of the Singapore High Court was not the end of that case, and I'll come back to that case. But what I would like to do before then is say a few words about international arbitration in general, and then talk about the different functions of the national courts in support of the international arbitration process, and then come back to the review of jurisdictional decisions, both positive when a tribunal finds jurisdiction and negative when it does not. So what is international arbitration? It is a process by which disputing parties, which can include individuals, private entities, public entities, and sovereign states, agree to submit their dispute to an arbitral tribunal which the parties have typically played a role in constituting for final determination according to the law that the parties choose. And the result of the process is binding in the form of an award that a party can be compelled to comply with by law. Once a party has agreed to arbitration, it cannot unilaterally withdraw that agreement. Most international arbitrations are international commercial arbitrations in the sense that they are arising out of commercial contracts between parties from different jurisdictions. Investor-state arbitration concerns disputes brought by investors against sovereign states arising under international investment treaties, and I will discuss this type of arbitration shortly. But at the heart of the international arbitration process is the parties' arbitration agreement, which will typically be included in the parties' contract. And it will stipulate that the parties agree to finally settle their dispute by arbitration, and by doing so, they forfeit the right to have it settled at court. The parties will usually agree also on the seat of arbitration, on the governing law of the dispute, any languages that will apply in the process, the number of arbitrators, and typically that the arbitration will be administered by an arbitral institution. There are many institutions in the world, approximately 50 of which are accounted for in the main International Arbitration Survey published every 3 years. Of the 50, 4 institutions have led the market for the last at least decade in international commercial arbitrations. That's the ICC, headquartered in Paris, the London Court of Arbitration, the Hong Kong International Arbitration Centre, and the Singapore International Arbitration Centre. There are 2 other centres that lead in the international investment arbitration space. That is the International Centre for Settlement of Investment Disputes, ICSID, based in Washington, DC, and the Permanent Court of Arbitration in The Hague, the PCA. Every year, these institutions receive hundreds, sometimes up to 1,000 new cases, and their ongoing cumulative caseload is much more than that. The international arbitration process holds a lot of appeal for international business and investment. This is primarily due to the fact that it's easy to enforce foreign arbitral awards all around the world, thanks to the 1958 New York Convention. That convention is now signed by 172 states, and it's implemented by national arbitration legislation in most developed jurisdictions. It does 2 critical things. First, it provides that the courts of member states shall recognize arbitration agreements. So when a court is seized of a matter in respect of which there is an arbitration agreement, the courts are obliged to refer the matter to arbitration, unless they find that there is no valid arbitration agreement, which in this circumstance, they would usually look at in a prima facie fashion. So if there's a prima facie arbitration agreement, the courts will send it to arbitration. They will not take the matter forward themselves. Second, it provides that states shall enforce foreign arbitral awards, except if there is one of a limited number of grounds for refusing enforcement. In Hong Kong, which has had a very long history of fiercely pro-arbitration jurisprudence, the approach is this: enforcement to arbitral awards shall be as mechanistic as possible. It's essentially almost a matter of administrative procedure. The courts shall not look into the merits of the dispute. The courts will only refuse enforcement if there is a real risk of prejudice or a material violation of a party's rights. And even if grounds for refusal of enforcement are made out, the court still has a discretion, nevertheless, to go ahead and enforce the award. In international arbitration, a measure of a good jurisdiction is that it is very slow to refuse enforcement of arbitral awards, as well as slow to set aside arbitral awards. And court practice in this regard is watched closely. I mentioned that the parties choose a seat of arbitration. This is a juridical concept rather than a physical one. So if the seat of arbitration is London, it does not mean that hearings have to be held in London, but they may well be. What it does mean is that the English Arbitration Act 1996 will apply to the arbitration procedure. English courts will supervise the arbitration and implement that act. And the award will be an English award for the purposes of enforcement as a foreign arbitral award under the New York Convention. The arbitration laws of most sophisticated jurisdictions are based on or owe very much to the model law promulgated by the United Nations Commission on International Trade Law, known as UNCITRAL, and New Zealand is included. This is a template legislation available for adoption or adaptation, and it reflects international consensus around the best process. Let's turn back for a moment to investment treaty arbitration because the regime is different. In the context of investment treaty arbitration, the arbitration agreement is found in the investment treaty in the form of a standing offer by the contracting states to arbitrate disputes with investors of the other state. And when an investor commences an arbitration, it accepts the state's standing offer and the arbitration agreement is completed. Most bilateral investment treaties provide for ICSID arbitration, but some provide for ICSID and or UNCITRAL arbitration. The difference between ICSID arbitration and other regimes is huge. If the arbitration takes place under the ICSID regime, the proceedings are governed by the ICSID Convention, which is a self-contained system in which there is no role for national courts. There is no seat of arbitration. Challenges to awards are made to ad hoc committees according to procedure that it comes within the system. And enforcement is under the ICSID Convention, not the New York Convention. Contracting states, such as New Zealand, enforce ICSID awards as if they were a final decision of the courts of their state. By contrast, if the arbitration takes place under the UNCITRAL rules, it will be governed by the national law at the seat of arbitration, just as was the case in the Sanem arbitration. The supervisory role of the courts engages in much the same way as it would in an international commercial arbitration. The awards are enforceable under the New York Convention, and applications to set aside the award have to be made to the courts at the seat. All of the investment cases I will speak about tonight are under the UNCITRAL arbitration rules. How might an ideal international arbitration play out? Let me give you a very simple example. Say we have a New Zealand company exporting wine to a mainland Chinese company. The New Zealand company does not want to find itself in a Chinese court if things go wrong, and vice versa for the Chinese company. So in their contract, they have agreed, they have concluded an arbitration agreement. They have decided on HKIAC arbitration, I wouldn't know why, seated in Hong Kong before a sole arbitrator. As the contract plays out, the mainland Chinese party stops paying its bills and the New Zealand party commences an arbitration. The HKIAC appoints a sole arbitrator. The arbitration is conducted under an expedited proceeding, and a final award is issued within 6 months saying that the Chinese party is liable to pay 70% of the damages sought by the claimant. The Chinese party decides that this is a lucrative contract. It wants to keep doing business with the New Zealand party. It decides to pay, and the parties go back to doing business. Nowhere in that example is there mention of national courts. And indeed, according to the ancestral model law, the starting position is the ideal level of intervention by the courts is none. The law says, in matters governed by this law, no court shall intervene except where so provided in this law. Ideally, one never needs court intervention. The ideal amount is as little as possible or only as much as necessary. And this recognizes the fact that the parties have opted for arbitration and they've made a conscious decision not to go to court. But the truth is that the process only functions because of the possibility, whether that be a threat or a promise, depending on what side of the question you're on, of court intervention. As put by Lord Mustill in 2002, arbitration cannot flourish unless judges are ready and waiting at the door, if only rarely allowed into the room. So, when are judges allowed into the room? What role do the national courts play in the international arbitration process? Let's stay with the ancestral model law. The rules bestowed on the court by the model law can be divided into two groups. On the one hand, there are those that are purely supportive of the process. In this group, I would place those functions under the model law in respect of the appointment, challenge, and termination of the tribunal's mandate. And in fact, most of these functions are delegated by the parties to an arbitral institution. So it's only in rare cases that a court has to, for example, appoint an arbitrator because one party hasn't, or decide a challenge to an arbitrator for lack of independence and impartiality. Secondly, the courts have a role in recognizing and enforcing and issuing interim relief in support of international arbitration. And this can take many forms, whether it be freezing assets or issuing an order to preserve evidence or issuing an anti-suit injunction because a party has commenced court proceedings elsewhere in breach of the arbitration agreement. And the third is assisting in the taking of evidence. The tribunal only has mandate over the parties before it. So sometimes court assistance is needed to obtain evidence from a third party outside of the arbitration, whether that be documents or witness testimony. All of these serve to facilitate the process. The second group of functions of the court go to its fundamental supervisory role, where it is ensuring that there does exist a valid arbitration agreement for the arbitration to even have validity, where it checks or it supervises whether or not the arbitration has been run in accordance with due process or in accordance with the parties' agreement. And also to ensure that the award deals only with matters that come within the scope of the parties' agreement, and to ensure that the disputes are arbitrable and are not contrary to public policy. So that's the court's supervisory role, and that is manifested by three functions we've already discussed. The first being the fact that a tribunal can be asked to review the jurisdictional finding of a tribunal after a preliminary decision, so early on in the arbitration process. Secondly, that at the end of the arbitration, the courts can be asked to set aside an award, including if there is no valid arbitration agreement or the tribunal has decided matters outside of its scope. And third, a party can request that a court refuse to enforce an award. And the grounds for refusing enforcement and for setting aside mirror each other and are derived from the New York Convention. So these are the functions of the national courts in support of the international arbitration process. And there is no shortage of complexities to every single one of them. So as Sir Ivor said in a speech he gave on judges as lawmakers, also quite a big topic, in 1985, with such a wide subject matter, there is a need to make arbitrary choices. So I will be doing something similar, And I'm focusing, as I've already said, on the court's power to review an arbitral tribunal's preliminary findings of jurisdiction or set aside an award for lack of jurisdiction. These are high-stake functions because they can bring an end to the arbitration process altogether. And that's why I've chosen. What is the standard that the courts must apply when reviewing jurisdictional findings? And what level of deference, if any, should they give to the findings of the tribunal? Let's return for a moment to the Sainem case. Sainem argued before the High Court that the issues were not justiciable, as they only concerned questions of pure international law in respect of a treaty to which Singapore was not a contracting party. The judge rejected this. He found that the case also involved the application of Singapore law, namely the right of a respondent or a party in an arbitration, which in this case happened to be the state of Laos, to have the tribunal's ruling on jurisdiction reviewed by the court under the Singapore International Arbitration Act. As an alternative argument, Sainem argued that even if the issue was justiciable, the standard of review was a limited one of deference and respect for the tribunal. The judge disagreed, noting that the standard for review under the model law is generally regarded as de novo, entailing a fresh examination of the issues. Sainem also argued that the qualifications and expertise of the tribunal counseled against adoption by the court of anything other than a limited review of the tribunal's positive jurisdictional finding. And the judge held that while he did not doubt the eminence or expertise of the tribunal, this did not mean that a limited standard of review was appropriate. Otherwise, it would mean that there would be a varying standard of review in every application, depending on the relative expertise and qualifications of the judge compared to the tribunal. On all of this, the judge must be right. Because when it comes to a review of a tribunal's findings on the existence of a valid arbitration agreement, there cannot be any deference to the tribunal's findings. It has to be de novo, both legally and I would say when necessary factually, because without a valid arbitration agreement, there can be no arbitral tribunal. Therefore, the tribunal cannot be the final determiner of its own jurisdiction. It has to be the court. Otherwise, the tribunal would be pulling itself up by its bootstraps. And also, while it is tempting to think that the respect for the authority and expertise of the tribunal should manifest in deference to their jurisdictional decisions, this also cannot be right. This is for the reasons given by the judge, and that it would be an unprincipled exercise of comparing CVs. But it's also because the existence of a valid arbitration agreement is a question of law and fact. And the arbitrator's expertise or eminence is not part of that inquiry. In reality, of course, the courts may often follow the jurisdictional determinations of eminent arbitral tribunals, but this should not be understood as a gesture of deference, but rather as a reflection of the fact that eminent tribunals are likely to produce correct, or at least highly persuasive decisions, at least some of the time. One might expect eminence and correctness to be positively correlated. But that is also always subject to the reality that reasonable minds, indeed brilliant minds, can differ. Sainem appealed to the Singapore Court of Appeal, and a bench of 5, led by the Chief Justice, reversed the findings of the High Court. They found that the treaty did extend to Macau and that Sainem's expropriation claims were covered by the treaty. On the question of whether the Singapore court could properly pronounce on the interpretation and application of the China-Laos Treaty, the Court of Appeal said that not only were the courts competent to decide these issues, they were obliged to do so, given their role as the supervisory courts. The court also confirmed that a de novo review was required and there was no basis for deference to be accorded to the tribunal's findings. It said, the court should consider the matter afresh. In doing this, it will of course consider what the tribunal has said, because this might well be persuasive. But beyond this, the court is not bound to accept or take into account the arbitral tribunal's findings on the matter. This does not mean that all that transpired before the tribunal should be disregarded, necessitating a full rehearing of all of the evidence. It simply means that the court is at liberty to consider the material before it, unfettered by any principle limiting its fact-finding abilities. And just a note in that in some instances, courts have shown deference to the fact-finding of tribunals, particularly where there has been extensive fact-finding by the tribunal or where the facts are particularly complex or belong to a specialized industry. What about negative findings of jurisdiction, where the tribunal decides it does not have jurisdiction? The model law on its face does not allow court review of negative jurisdictional findings. At the time of the drafting of the model law in 1985, it was updated in 2006, but not in this context, whether to include a court review of negative findings of jurisdiction was considered, but rejected. And it was thought that it would be inappropriate to compel a tribunal to continue with an arbitration over which the tribunal had determined it had no jurisdiction. Notwithstanding that, in multiple important jurisdictions around the world, both model law and non-model law, the legislation has departed from the model law approach on this. The jurisdictions include Belgium, Canada, England and Wales, France, India, Italy, New Zealand, Northern Ireland, Scotland, Singapore, Sweden, Switzerland, and the US. But despite what appears to be growing momentum in this direction, the question is not settled across all jurisdictions, and there are still important jurisdictions that maintain that there is no court review of a negative jurisdictional finding. That includes Hong Kong, Germany, and the Netherlands. And indeed, in 2 cases seated in The Hague and a third seated in Paris, the issue has recently come again to the fore. These were investment treaty cases involving investors with dual nationality who were suing the state of one of their nationalities. The first case was brought by a dual Egyptian-Finnish national, a Mr. Bhagat. He invested millions in Egypt after winning a government bid for a 30-year mining license. But not long into operations, things became very problematic for him. He faced criminal charges and he was sentenced to prison for 15 years under hard labor, and his assets and those of his companies and his family were seized. He spent 3 years in prison, was then released, remained in Egypt under a 2-year travel ban, but once that was lifted, he left the country never to return until his death in October last year. While the authorities lifted the seizure over his assets and those of his family, they did not with respect to his businesses. In 2011, Mr. Bhagat brought a claim against Egypt under 2 bilateral investment treaties concluded between Finland and Egypt. And the fact that there were 2 investment treaties doesn't matter for present purposes. I just say it to be accurate, but what these treaties offered protection for, they offered protections to investors who were defined in this way. Any natural person who is a national of either contracting party who invests in the territory of the other contracting party. At issue was whether Mr. Bhagat could bring the claim as a dual national. given the international law principle of non-responsibility, which says that an individual cannot sue its own state before an international tribunal. And in the context of dual nationals, that principle has gradually given way to the principle of dominant and effective nationality, whereby a dual national can only sue the state which is not that of his or her dominant nationality. The tribunal in Mr. Bhagat's case found that it had jurisdiction. It reasoned that the general international law principle must yield to the lex specialis of the investment treaty. And while some investment treaties expressly prohibit claims against dual nationals, the Finnish-Egyptian treaty did not. And while dual nationals are not eligible to invoke exit arbitration, because there is an express prohibition on dual nationals in the ICSID Convention, this case was under the UNCITRAL arbitration rules and there was no such restriction. 2 years later, Mr. Bhagat's tribunal issued a final award holding Egypt liable for $44 million plus interest and 90% of his costs. Meanwhile, around the same time that Mr. Bhagat started his arbitration, 2 other disputes arose. They involved a family originally from the Canary Islands in Spain who had moved to Venezuela in the 1950s and 60s. And there they'd started working for a food marketing and distribution company, which they later acquired. And at the time they acquired it, it consisted of a rented warehouse, 2 employees and 1 van. Over the next few decades, the business grew to multiple facilities across the country, investments in supermarkets and real estate, and a fleet of 170 vans. All of the family members started out in the same business, but in the mid-1990s, one of the brothers divested and went out on his own with his daughter in the same industry, but with a separate company. Then came 2009, and there was a sharp drop in oil prices, and this caused great trouble in Venezuela. It caused a great loss to the drop in the social budget. And in the food sector, there were serious supply problems for the state-owned company that was dedicated to distributing food at subsidized prices. To cut a long story short, the state acquisitioned the property and assets of the claimants, including the brother, and no compensation was paid. In 2012, the brother, whose name is Serafin Garcia Amas, and his daughter Katrina Gruber, commenced arbitration against Venezuela under the Spanish-Venezuelan BIT, Bilateral Investment Treaty. And that treaty defines investors as any physical person who possesses the nationality of one contracting party and makes investments in the territory of the other contracting party. Very similar to the treaty language in Mr. Bhagat's case. In 2014, the tribunal determined that it had jurisdiction in that case, as the treaty only imposed a positive requirement of nationality of one or the other contracting states, but not the negative requirement that the individual not simultaneously hold the nationality of the other contracting state. In 2009, Serafin Garcia Amas and his daughter received an award holding Venezuela liable for damages for $215 million, interest in a similar amount, and 100% of costs. That case was seated in Paris. Venezuela tried to set it aside in Paris, but the Paris court rejected that application and followed the reasoning of the tribunal. Meanwhile, the rest of the family, the rest of the Garcia Amas family, having seen that their brother did so well on jurisdiction under the Spanish-Venezuela Treaty, commenced an arbitration in 2015. But, you could all hear the but coming. In their case, the tribunal held that it had no jurisdiction because of the claimant's dual nationality. It held that the principles of general international law apply unless expressly derogated from under the lex specialis of the investment treaty. And while dual nationals were not expressly excluded, nor were they expressly included. Plus, the dispute settlement provisions to be invoked at the choice of the investor listed first ICSID arbitration and only then UNCITRAL arbitration. The tribunal concluded that the order of listing had a hierarchical meaning. And because ICSID arbitration did not allow dual national claims, that limitation must then implicitly apply also to UNCITRAL rules arbitration. The tribunal could not accept that the definition of investor could be changed depending on which procedural forum the investor chose. It declined jurisdiction. The seat of arbitration in the Bagat case and in the Garcia Armas family case was The Hague. Any application for review of the tribunal's jurisdictional determinations would be to the Dutch courts. In March 2020, in uncannily timed applications, Egypt applied to set aside the tribunal's positive jurisdictional findings, and the Garcia Armas family applied to set aside their tribunal's negative jurisdictional findings. In the Bagat case, the court confirmed that dual nationals were covered by the definition of investor in the Finnish-Egypt treaties. It agreed with the tribunal's finding on jurisdiction. The Garcia Armas family application was first dealt with by the Dutch Court of Appeal. In a judgment dated January 2021, the court declined to substantively review the tribunal's negative jurisdictional award. It held that the law did not empower it to do so, to set aside an award by which a tribunal declined jurisdiction based on the absence of a valid arbitration agreement. This was appealed to the Dutch Supreme Court, which in April this year upheld the decision of the Court of Appeal. Imagine if the rest of the Garcia Armas family had chosen Paris as the seat of arbitration instead of The Hague. There, they would have been able to review the negative jurisdictional finding. And because the French courts had already decided that dual nationals were not excluded by the same treaty, there's a high likelihood they would have been successful. Or imagine the Dutch legislation allowed the review of negative jurisdictional findings, because those courts had concluded in the Bagat case, dealing with very similar language in a treaty, that dual nationals were not excluded. The choice of seat was a multi-million-dollar decision in this case. Not allowing court review of negative findings on jurisdiction has been criticized for some time and for several reasons, which I think we can appreciate from what we've just heard. But the principal one is that it is inconsistent to deny the jurisdictional review, the judicial review of negative jurisdictional rulings while allowing review of positive jurisdictional rulings. Because injustice can just as easily be served. That injustice can just as easily arise where a tribunal makes an erroneous negative jurisdictional finding than when it makes an erroneous positive one. It also does not treat the parties equally. It gives a respondent an opportunity to challenge a positive finding, but does not give a claimant an opportunity to challenge a negative one. Also, a negative jurisdictional award sends the parties back to the courts they intended to avoid in the first place, namely the national court of one of the parties. In a domestic setting, this might be fine, may not lead ultimately to any unfairness, but in international cases, it can be very problematic, where one side will suffer for finding itself in a foreign legal system, whether that's simply due to matters of inconvenience, like being unfamiliar with the legal system, language barriers, travel costs, the inability to have your own lawyers appear for you in front of the local courts, through to much more serious issues like lack of judicial independence, excessive delays in courts, which can sometimes effectively be a denial of justice, unqualified judges, undeveloped, unclear, or unfavourable law. The downside to no review for negative jurisdictional findings is even more pronounced in investment treaty arbitration, because a claimant's substantive treaty claim is extinguished by a negative jurisdictional ruling. There is no other court before which a claimant can bring a claim against the host state, and whether a claimant can bring a claim against the host state in its domestic courts is another question, but is fundamentally unappealing in many cases and literally dangerous in some. In conclusion, what these cases show first and foremost is that the choice of seat is critical, and the choice of seat determines the legislation that will govern the arbitration. And while there is much commonality across different sophisticated jurisdictions, there still exists important differences, and parties must be well advised as to what their choice of seat means. For their part, national judges can only implement and interpret legislation. They cannot change it. While there is a strong emphasis in international arbitration on non-intervention by the courts, the system depends on the court's power to intervene to function. The court's intervention may be purely facilitative. For example, the judges may order the production of relevant documents into the room, but it is also supervisory in a fundamental and absolute sense, and that judges have the power to decide that there is no basis for anyone to be in the room in the first place. Determining when to exercise that fundamental supervisory power is one of the most challenging aspects of the national court's role in the international arbitration process. And finding the right line is difficult and best left to the careful judgment of those mandated to dispense it. Thank you very much.
That was wonderful, Sarah. Thank you. My name is Graham Austin. I'll give the vote of thanks in a moment, but Sarah's kindly said that she'll take some questions from you. So over to you.
Daniel and then Suki. Oh.
Sarah, one earlier. Yeah, I have brilliant, but judging has agreed, but I think it's rather than I of course. Then I have in legislation. That is one manage to avoid.
Thank you. Daniel? Yeah.
Yeah.
Yeah, so you're exactly right, Daniel, that, some of the older treaties concluded by China have this very restrictive scope of what can be arbitrated. And it's also, you find it in lots of different communist states or former communist states around Asia. And that's because those states at the time when they were concluding the treaties were not capital exporting, they were capital investing. So they were looking at their treaties from the position of potentially being a respondent state rather than being an investor suing a state. But in this particular case, the treaty contained a fork in the road clause. And so what it provided for was arbitration first before the domestic courts in Laos. And the court had the ability to determine expropriation and the amount of expropriation. And then if you didn't choose that route for your dispute resolution, the other option was international arbitration. And the tribunal found that because of the fork of the road, if you chose to go down the domestic court route, the domestic court had the power to determine the amount of compensation for expropriation. And that meant that that would effectively foreclose the international arbitration option, which would mean that the provision that provided for international arbitration became useless. It had no meaning. And so to read in full meaning to all of the provisions of the treaty, the tribunal took the purposive approach and the expansive approach, which a number of different tribunals have taken. Some have gone the other way, but most have, I don't know most, but many have taken that expansive approach. And that's what the tribunal did in that case. And this issue will come up again and again and again because these treaties are still around.
No more questions. Yes.
Yeah, well, I have tried to figure out why, for example, the Netherlands has chosen to keep negative jurisdictional review precluded. And what I have found is that this is not very satisfactory, but that allowing that goes too far, that if there is no valid arbitration agreement, the buck stops with the tribunal, and the legislation provides then that the court's jurisdiction comes into play. And that may be the domestic courts if we're talking about a domestic arbitration, or the relevant competent court if we're talking about an international arbitration. And so there is a distinction to be made, however, between if the tribunal finds that it lacks jurisdiction because there's no valid arbitration agreement, or if it finds that there is the matter before it is outside the scope of an arbitration agreement. It is not entirely clear whether that jurisdictional objection would be whether that jurisdictional finding, if negative, would be reviewable by the Dutch courts. I think that there is some space there for argument. With respect to Hong Kong, my understanding, this was in the context of legislative reform that took place back in 2008, leading to the 2011 enactment of the legislation there. There was a lot of pushback from the construction industry. And I think that that is because of the desire for finality, that if you get the negative jurisdictional finding, you don't want to then have to go through the challenge process in the courts. And in the Hong Kong arbitration industry was built around the construction industry. And as you know, in construction disputes, you have big projects, but you have multiple disputes along the way. And there needs to be a way to move on from them quickly to move on with the project. I don't know about the motivations for Germany. There was an early court case which interpreted the model law to say there is no room for negative jurisdictional findings review. But I'm not sure if there's been any legislative reform looking at that in any specific way since.
One last question. Yeah.
Kia ora, ngā mihi kia koe, i tō kōrero. Yeah, I was impressed by your depiction almost of picking your arena to go and have your hearing. And are you seeing any process whereby in bilateral arbitral agreements, some definition as to what is to be the arbitral environment that any disputes are to be heard in? So to avoid your Venezuelan example where one went to The Hague and one went to Paris and ended up with quite different results.
Yeah, so in terms of how the choice of the seat is made, it depends. So the parties will very often agree already in the contract. So there, it's in the contract. Sometimes the parties won't have agreed, and then it will sometimes be in the arbitral procedural rules that apply. So for example, in Hong Kong, it was a very deliberate choice to include Hong Kong as the default seat if the parties hadn't agreed, so that there would be no space and time with there being no seat of arbitration once the arbitration is commenced. By contrast, that's not the case in Singapore. In Singapore, there is no default seat of arbitration. And that's as a gesture towards party autonomy, that in the hope that perhaps the parties will agree one. If the parties haven't agreed, sometimes the institution will decide. The ICC Court of Arbitration has that power to determine that. And I remember when I worked at the ICC Court of Arbitration, we would be making recommendations to the court. And if we had a case that had no seat, I remember going up to a big world map on the wall in our office and trying to find a good jurisdiction that was a member state of the New York Convention that was neutral between the different countries of the parties. But that's some of the thinking that goes into it.
Oh, kua mutua mātou mahi I tēnei wā, or it's really say, Sarah has finished her work for tonight, and wonderful work it was too. Hello everyone, as I mentioned, my name's Graham Austin. I'm one of the members of the faculty here at Victoria University of Wellington, together with Justices Collins and Koch and my colleague, Professor Petra Butler. I was one of the people who assisted their honours with the thinking behind the Ivor Richardson lecture. And this evening, I've been given the significant honour of moving the vote of thanks. I'll be very brief, I promise, as anyone who's been in this position knows, I stand between you and refreshments. And they are, I've been instructed to tell you, up there in the mezzanine floor. So after these few words, if you could go up the back there and miraculously refreshments will appear. Actually, they appear because of the hard work of our professional staff. Listening to Sarah Grimmer this evening deliver her remarks, the thought came to me, as I'm sure it came to many of you, how proud Sir Ivor would have been of the very hard work that Sarah has done for us this evening. Justice Cooper and Dean Godden talk eloquently about Sir Ivor's public life and public achievements. I just want to say something about the more private environment. When I came back to this country, Sir Ivor was a distinguished fellow at this law faculty, and he took that role very seriously. He offered unswerving support for the scholarly work that occurs here. He was always a sounding board for ideas. He always bolstered the endeavour of advancing new thinking about the law. And he was always very gracious and challenging toward those of us lucky enough to work here, insisting that creativity be tempered by discipline. And then, if the past few weeks have shown us anything, our institutions require friends and champions, and Sir Ivor was both. I got to know Sarah a few years ago when I was in Hong Kong. There was an alumni event scheduled for when I was there. Sarah's punishingly busy schedule didn't allow her to come to the evening event, but she sought me out, insisted that we had breakfast the next morning. It was a great conversation, and it was immediately clear to me that Sarah is also a champion and friend of this law school, and she has been for many years. And this continues with your willingness to come back to where your legal education started and enlighten us with your remarks tonight. And what a perfect topic for the Sir Ivor Richardson Lecture in Private Law. In an address that only a true expert could deliver, one that manifested both creativity and discipline, Sarah has challenged us to think about both the party autonomy that animates international arbitration and the role of public societal institutions, courts, that give that kind of background support needed for this manifestation of party autonomy to flourish. So, focusing on the question of an arbitral tribunal's jurisdiction and jurisdictional competence to decide about such matters, Sarah's remarks ask us to think about the role of national courts' supervisory role in a dispute resolution context where the parties have deliberately tried to remove themselves from, at the very least, the effects of substantive and procedural determinations by those same courts. And these jurisdictional issues take us right up to the point where party autonomy comes hard up against the problem of how to avoid, to use the phrase that Sarah quoted, tribunals pulling themselves up by their own bootstraps. And Sarah's discussion of the claims against Egypt and Venezuela show us that these kinds of issues have enormous practical relevance for the parties, private law in action, indeed. And these are the characteristics that make your remarks such a perfect beginning to the Ivor Richardson lecture series in private law. Sarah's will be a difficult act to follow, but I think we can expect future speakers in this series to continue exploring, albeit in an array of different contexts, many of the themes that you have so expertly explored in your remarks this evening. If private law is about anything, it's about horizontal relationships between citizens and other private parties. It's about spheres of life structured by legal institutions such as property, contract, equity, bolstered by the protections afforded to rights and interests by doctrines in fields such as tort law. But those private choices reflecting both practical decisions about how to arrange affairs as parties see fit, and an expectation that those decisions be respected, count for little if we do not always also have expert and ethical public institutions that honour those private determinations, institutions that intelligently ask the kinds of questions that Sarah explored tonight. Who decides? What should shape our decisions? And what ultimately is our role? With tonight's lecture, Sarah has enhanced our understanding of all of these issues and more. Now, my roles are just four. Again, to thank the Court of Appeal and the Boren Foundation for the support of this lecture, to thank you all for coming, to remind you to join us for refreshments upstairs, but most of all, to thank Sarah Grimmer for sharing some of her expertise so generously and graciously this evening. Please join me in so doing. Tēnā koutou, tēnā koutou, tēnā koutou.